Let me first of all welcome you. You know how much I enjoy seeing the familiar names and familiar faces. I always thought of myself as a hermit, but my wife Beth tells me that somehow your community has turned me into some sort of a sociable person, because I really love and enjoy seeing you, as long as you don't give me a tough time tonight and agree with everything I say. So let's get started. I'm just looking off in the corner and Lay is not writing that to me. Okay, so first a little disclaimer of sorts, because when this idea first was proposed, we were in the midst of a raging debate in the United States of America about the role of the Supreme Court, what kind of court we want, what powers it should have. And of course, we all know of a beloved other country that is now in the midst of a even more tense debate over that. And this course is really about American judicial review, the emergence of judicial review. Despite its controversial and provocative title and blurb, it really is, in many respects, a straight history course of sorts. And for that reason, even as you participate and we debate some stuff, there might be some dense material as well. But let's get started. I'm going to just get the slideshow ready. Get it on. And it's not one of those slideshows where I just read from it. Okay, so here we go. I'm going to share the screen.
Dr. Jucovy, are you okay? Do you need something?
No, it just takes a few bits of manipulation here. Okay, so I'm going to put that on as a full screen and let's get started. So I think all of you know that I love myth busting, and there's a lot of mythology about judicial review. In some respects, the idea that Marbury v. Madison initiated judicial review, and here I'm being a little bit pedantic, has to be wrong because the term itself didn't even exist. The term judicial review was coined by a historian of the court, Corwin, in the 20th century. And Corwin didn't only invent the term judicial review to describe something, but he, in effect, began to define it. And he actually ends up compiling a list of all the instances in which, or what he claimed were all the instances in which the United States Supreme Court had canceled, declared unconstitutional a congressional law. And that Corwin's list is itself been added to, subtracted from. It's not the definitive list. And it's not the definitive list for another reason as well, not just that others have added to and subtracted from it, but because it didn't include the list of all the times the court had heard cases involving congressional enactments and had declared the congressional enactments to be constitutional. So judicial review is something which didn't have a single moment of birth. We humans love to point to something and say, this is when it started. But in many cases, there is no actual moment in which there's a beginning. There is the emergence of something, its evolution, its development. And then we look back and say, this thing is something and it has a beginning. And usually that's not true. And it's not true of judicial review as well. All right, so let me go back and talk about the origins of this thing called judicial review, what it was, what it became, what it is now. First of all, judicial review is something which was unique to America. It really is something which emerged in the United States of America. And that it emerged in the United States of America is really, in a sense, almost ironic. And I think if we look at the colonial period, you'll see why. Courts in colonial America were despised. The idea that judges should have control over our lives was despised. And the reason for that was because the judges in the United States of America, well, in colonial America, were appointments of, appendages of the king and their royal governors in the colonies. And these magistrates were even referred to often as the servants of the king or of the governor. And the term that was used for them was usually magistrate, not even judge. And the magistrate was the same title that was given to the governors as well. They weren't only royal appendages carrying out royal orders, which were often regarded as being noxious, but they didn't perform single tasks as judges, as magistrates. They often had dual tasks, serving as officials in other capacities, Stamp Act officials, judges, etc. So the idea that they were committed to one task and independent, it didn't exist. And as I said, they were hated. And as a result of that, in the United States, or in the colonies preceding the United States of America, the colonists developed a barrier, a counterpoise against them. And that was the colonial juries. And let me look with you at a document which I think helps to express the attitude that the colonists had about the juries and the role that juries should play. So let me get on the proper slide here. The juries in the minds of the American colonists were the representatives of the people, and the juries in the eyes of the American colonists should have a capacity to overrule the magistrates, to interpret the law on a par with the magistrates, and that would be something which would keep the magistrates from becoming all too powerful. And when the revolution was made and the colonies became independent states or parts of the United States of America, the new states that were set up established a judicial system that was very different from what we have now, or at least a majority of the states did. They established, by and large, a legislative dominance, a legislative supremacy. And in about 5 of the states, you did have some degree of judicial review, but in many of the states, you had the state legislatures that were in control. But in the eyes of many of the privileged people in the country, the elites, the gentry, the ones who regarded themselves with a small a as being aristocrats, these state legislatures were endangering liberty in the United States of America. They were acting repressively, and they were invading the rights of minorities. And this is a quote of one of the claims that was being made against them. They were the eccentric impulses of whimsical, capricious, designing men. One thing that the new country tried to do to try to keep the judges and to keep the legislatures from acting out of control, well, there were two things that they really tried to do. As far as the judges were concerned, Thomas Jefferson, and here you see a picture of Jefferson, believed that the laws should be codified by legislatures. He thought of a legislative solution in such a precise way that there would be no need for and no room for judges to engage in any degree of interpretation. Codification was the solution. Judicial review, the idea that judges should review the laws and in effect make laws, he regarded as being essentially repugnant. So that was the codification approach. But the legislative solution didn't seem to work. The legislatures in the states that had the legislative supremacy enacted law after law after law, because as they came upon a new situation, they'd make a new law. Because they were often not trained lawyers, because there was widespread suffrage at that time, the laws themselves were poorly drafted. They overlapped each other. And in the eyes of the small a aristocracy, they were oppressive to minorities. And we'll come back to what that actually meant to be oppressive to minorities. And so there was a growing sentiment during the 1780s that legislative supremacy just simply was unworkable and dangerous. And there was a reversal of sentiment. Instead of courts being the enemy and judges being the enemy, there was a growing sense that we needed judges and that we needed courts as the only body of men who will have an effective check upon the assembly. So I want to go into a little bit of detail about the Rhode Island case. I'm actually curious if anybody dares to speak up. Does anybody know the Rhode Island issue? I feel like calling out somebody. Okay, so the Rhode Island issue is an example of the democracy that reigned during the 1780s. Rhode Island was probably one of the most unruly democratic states in the United States of America. It was called often by those who despised it, Rogue Island. And during an economic depression in the 1780s, when prices on agricultural products plummeted and people's debt was unable to be repaid, Rhode Island passed a law, a law that declared that all paper currency issued by Rhode Island had to be accepted by fiat. Anybody who had that paper currency could use it, even though the Rhode Island paper currency ultimately became relatively worthless. And one of the merchants who was given that paper currency sued in the Rhode Island Supreme Court. And the case that he brought was that the law that had enacted this requirement that he accept the currency was unconstitutional, because according to the charter granted to Rhode Island by the king a century earlier, essentially, more than a century earlier, everybody in Rhode Island had a right to a trial by jury, and this law did not give a trial by jury. So the court heard the case, and I think the slideshow is going to be posted, so there's a link to it that you could look at on a website. The court heard the case, and the court refused to render a decision. It said that because this law did not give a jury trial and was claiming that the Supreme Court was the one to hear this case, they really had no capacity to hear the case. They had no right to hear this case, and they refused to hear it. So what happens then is that the Rhode Island Assembly summons I think it was 5 judges, and it fires 4 of them, it dismisses 4 of them, and appoints 4 new judges who are all in favor of the paper currency. And the charge against the judges, the impeachment charge essentially, was that they had violated their position by declaring a Rhode Island legislative act to be unconstitutional. And this case is often pointed to as an example of the pre-Marbury v. Madison, pre-Constitution proof that judicial review as we know it, or close to as we know it, was something which was already happening in the colonies before the United States of America, before the Constitution, or in the early United States. I wonder if anybody sees the odd thing that happened in between the court decision and the Assembly's impeachment. Does anybody catch the anomaly or the mistake that was made, which then became the dominant historical story? Well, what did the court do? Danny, you don't answer first. I'm going to call on you.
Well, I was thinking it was a bit odd to declare something unconstitutional without a constitution.
Well, Rhode Island had a charter.
Mm-hmm.
So that's the constitutional claim, so to speak. But what was the court's decision, literally? I mean, you don't see the language of it, but it refused to render a decision, right? It said that it did not, in effect, have standing, the capacity to render a decision, because the law, the Constitution, so to speak, required a jury, and they were not a jury. So let me ask it in a slightly different way and see if I'm giving a good enough hint. What didn't it do about the law?
It didn't nullify it.
didn't nullify it. It didn't actually declare the law to be unconstitutional. And it's interesting that the assembly accused them of doing that, even though they didn't actually do that. And the assembly's accusation is the one that's gone down in most historical accounts of this, but it's actually not what happened. It was a limited limitation on the legislative rights, in a sense, because it refused to carry out a legislative direction that they should hear this case in effect through the law, but they didn't actually declare the law to be unconstitutional. So what does it show? What it really shows is there certainly was a widespread feeling within the United States of America pre-Constitution, and it actually dates back to colonial times, that courts do have some capacity to defy the legislature. There's absolutely no doubt about that. It also shows that the nullification, the canceling of legislative acts, was not necessarily something which happened very much, even though it may have happened occasionally. The ones who like to claim that judicial review has a long, sterling history and goes back to these times, well, what they had was something a lot more limited and a lot rarer. And the Rhode Island case was, not an indication that we have anything close to modern day judicial review. There were examples in New York in which you had bankruptcy laws being passed, and the court in New York declared them to be null and void. And New York just went ahead, the New York legislature went ahead and fired all the judges. I think they actually passed a law which took away the power of whatever courts were left to rule on legislative enactments. So there's a real debate taking place in the early United States at that point over the role of the judges, the role of the courts, the role of the legislature. And then the Constitution gets written. Now, those of you who've had my class relatively recently know that I take a position, which is hardly a rare one, it's not an outlier, that the Constitution was hardly written in order to advance democratic privileges in the United States of America. Rather, it was written in large part to provide protections for minority rights. And by minority rights, I mean, well, I don't mean slaves. I don't mean Native Americans. I don't mean women. What's the most significant minority which felt under attack during the 1780s? The minority of propertied people, very well-propertied people. And they felt that legislative acts in the states were running riot and threatening property rights which they felt were the basis of civilization and society and order. And they felt that genuinely. I'm not someone who thinks they were hypocrites trying to hold on to their money. I think they genuinely felt that society required property and property to be protected. So the Constitution was, I think, in large part written to provide protections by limiting democratic privileges and providing very definite protections for property. And one of the ways in which property was to be protected was by making sure that the courts had a greater degree of authority than they had during the colonial, well, not colonial, but the early United States period. And this was something which was contested. The Anti-Federalists put up a strong campaign, a vocal campaign against the Constitution. They lost it, but they made some very, very cogent arguments, including about the role of the National Judiciary. And Hamilton, who wrote Federalist number 81, responded to these anti-Federalist arguments concerning the courts. And I want to take some look at it, a little bit of detail. So this is Hamilton laying out the position of the Anti-Federalists. It's not the Anti-Federalists themselves speaking, but it's a good summary, I think, of their position. I think it's an honest, accurate summary of their position. So I'm going to actually take the time to read it and go over it. The authority of the proposed Supreme Court of the United States, which is to be separate, will be superior to that of the legislature. So even then, the anti-federalists believed, and obviously I think they turned out to be right, that as the Constitution was structured, the Supreme Court would become the superior branch, the dominant branch, largely because the power of construing the laws according to the spirit of the Constitution will enable them to mold it into whatever shape they may think proper, especially as its decisions. So number two, the second point is they're not only superior, but they're going to be superior because they get to say what the law is. And famously, I don't remember now which Supreme Court judge said this when asked what the Constitution meant. I believe his answer was whatever the Supreme Court says it means. And the anti-federalists early on were making the claim that that's exactly what the court would do, that they would determine what the laws were, what they weren't allowed to be. And then there will be no way of revising or correcting, maybe think proper, especially as decisions will not be in any manner subject to the revision or correction of the legislative body. There is no overriding of their decisions, no overriding as there is with the executive, no check on it is their claim. And then it's dangerous. In Britain, the judicial power resides in the House of Lords, which is a branch of the legislature, and that's what they're recommending here. The Parliament of Great Britain and the legislatures can at any time rectify by law the exceptional decisions of the courts. There is a check on the courts. So that's the claim. They're superior, they can make the law, and there will be no check on them. They will become uncontrollable and remediless. All right, let's see how Hamilton answers that. So his answers are, I used to think his answers were disingenuous, that he didn't really believe this and he was just making polemical arguments. I've now come to the belief that he really believed it. All right, so what's his first claim? Take a look at this. Read the actual quote that I excerpted. In the first place, there is not a syllable in the plan which directly empowers the national courts to construe the laws according to the spirit of the Constitution, or which gives them any greater latitude in this respect than may be claimed by the courts of every state. So he's making two rebuttals here. One is, well, the Constitution doesn't actually lay out that the courts can do what the anti-federalists are claiming it could do. It doesn't give them the power directly to construe the laws according to the spirit of the Constitution. And secondly, insofar as the courts have some power about the laws and the spirit of the Constitution, every court in every state claims the same thing. So he's getting his argument two ways. It's not doing what they say it's doing, the Constitution. And even if it is, it's no different than what the states have. So what's so terrible about that? So anybody have any comment on Hamilton's claims and what it shows about the emergence of judicial review?
No, but I think that Charles Evan Hughes said that quote, if I'm not mistaken, in case you cared.
Charles Evan Hughes said what?
That the law is whatever the Supreme Court says it is. I chatted.
Oh,
You ignored my
said
chat,
what?
and so I just wanted you to know I was here.
Well, hello,
Yes,
Sarah,
attention.
and thank you.
Hi.
Charles
Sorry for
Evan
the loss.
Hughes. Okay. So any comments on the Hamilton quote?
I mean, I think I would add to this. To me, what it seems to show is that, as you were saying a moment ago, the power already the power of judicial review already resided in the courts, and that's what I think what he's saying when it says there's nothing that directly empowers the courts to do that. I think it's essentially a recognition of the fact that courts, particularly the state courts, have that power. And I think I'm reading here, you know, between the lines, he's basically saying these national courts are courts of limited jurisdiction, as we now think of them, and the state courts are courts of general jurisdiction. So in fact, anything the national courts can do, the state courts can also do. And so
Right. And I think what's important about this is actually What it goes to is the widespread claim, which I was guilty of making decades ago, that if you look closely at the language of the Constitution, I used to say it was clear that there was no empowerment of anything approaching judicial review, that's something which gets invented subsequently and is not really part of the original intent of the Constitution. And what Hamilton's answering, what essentially saying here, and I'm now going to paraphrase, is, well, of course, we don't spell out that the courts have some power like this. It's not directly there, but it doesn't have to be directly there, because we know damn well that that's exactly what we mean when we say that the courts can hear cases under the Constitution, that it has some sort of a, how extensive, how limited it is, well, that we're going to go into in a little while, but it has some sort of authority and claim to be able to make decisions by consulting the Constitution. So, those who say judicial review was added on subsequently by Marshall and his decisions, that's clearly not true, I think. And Hamilton is in effect demonstrating that with his argument. So now I want to actually pause the looking at Hamilton's response to the Anti-Federalists, because I want to talk about this business of, let's go back to his line, construe the laws according to the spirit of the Constitution. So I go on quite a bit about this in my classes, because like anything I discover after I went to high school, that contradicts things that I learned in high school, I tend to get very worked up about. And the idea that constitutions are higher law that courts take into consideration when they render judgments was something which I simply took for granted. As in effect, it's like nature, it's like a law of gravity. That's what constitutions are. They're the most important, highest law of the land. And like any other law, they have to be consulted by courts, considered by courts. And since they're the highest one, they're the last thing that one looks at, the final authority. And that's actually something which also doesn't have a moment in which it began. It's not something that got invented in a single time period. It's something which emerged over time. And it emerged in the course of a serious debate, a serious conflict about what a role of a constitution should be. There's a wonderful new book came out within the last year, right, Sarah? Are you reading it?
I have it.
You have it.
I'm first finishing my book on the Prince Harry, obviously.
Oh, okay. Worthy reading. So, written constitutions is really a piece of the 18th century when there was the explosion of written constitutions, which has continued more or less ever since. But what exactly a constitution, what role it plays in society and in the courts, is something, as I said, which was debated, contested, and emerged over time. So back in England, which is where we get most of our legal customs, back in England, it was taken as a given that the English Constitution, which of course we all know is essentially not a single written thing, it consists of written parts and customs and court decisions and so on and so forth. The English Constitution was regarded as being, of course, the highest law of the land. But what the highest law of the land meant was that I call it either aspirational or inspirational. Parliament, the courts were all expected to consider what they thought the British Constitution or the English Constitution required, allowed, didn't allow in their acts as legislators, their acts as justices or as magistrates, executives. Aspirational in the sense that if Parliament by a majority decided on one law, presumably what just took place was that parliamentarians had consulted their inner thought, their inner reasoning and conscience, and tried to come up with a law which they thought accorded with the spirit of the English Constitution. And if they passed that law, then it was regarded as being in the spirit of the English Constitution. There was not any court which could actually tell them that they were wrong. And there was no document that they had to consult and make sure that they were according to the words of that document. They just simply had to aspire to what they thought the Constitution represented, the ideals of their countrymen in making that law. And that's something which was essentially what most American colonists believed, except that by the 1780s, a different idea had begun to emerge and was becoming increasingly dominant. And that is that America had a written constitution. And that written constitution meant, and here I'm quoting Iredell, was not a mere imaginary thing with everybody having their own opinion on it, but a written document that we could all look at, and therefore the judges have to consider when they make decisions. So now you have two competing ideas in the United States of America. The idea that a constitution should be something, even if written, was simply procedural and aspirational. So in other words, the United States Constitution, according to those people, was something which required that a senator serve 6 years, or that a president had to be, 35 years of age in order to be a candidate for the president and eligible for the presidency. Those are simple procedural things. But as far as what the legislative powers are in that enumerated list, what the powers of the states are that are retained by the states, what are the powers that have been taken over by the national government, those are not simple procedural things. They require interpretation. But for those people, it was not for the courts to make that interpretation. It was for the American Congress to make that interpretation. If they passed a law trying to keep with the spirit of the Constitution, then that law was not something that the courts could examine and say it violates the higher law of the land. The higher law of the land, the Constitution itself, was not to play any role in judicial decisions, in court proceedings. So that's Constitution as aspiration. But Iredell, of course, said the opposite. It's not a mere thing. The assembly does not have a right to violate the Constitution. Well, that cut and paste didn't work too well. The judicial power has to take into consideration the written constitution of the land in considering the law. And that idea was something which began to spread, as I said, in the United States of America. Thomas Jefferson generally believed the initial idea, and certainly never came around to the idea that the Supreme Court of the Judiciary had the unique power to interpret the Constitution. The position of people like Madison and Jefferson to the end of their lives was, all right, the Constitution plays a role in the activities of the branches of government, but each branch takes into consideration the Constitution in its own capacity. The executive executes laws that he thinks are constitutional. The legislature passes laws that they think are constitutional, and the judiciary renders decisions on the basis of what they think the Constitution permits or doesn't permit. A lot of people think that might lead to anarchy, but Jefferson and Madison thought that it was the only logical way to use the Constitution in the actual business of government. All right, so Hamilton's first argument is essentially that the Constitution is going to play a role in judicial decision-making. So now he talks about, let me go on actually to this one, this other argument that he's making. So he's saying that a legislature, this is in answer to the claim that legislatures have no check on the judiciary. that Congress actually has a number of checks that it has on the judiciary. Another thing that a legislature can do is clearly to pass a new law if the law that they had passed is rendered inoperable, null and void by the courts. This, by the way, is the claim that a very, very famous president, important president of the United States, made in a case that President George Bush described as a terrible, terrible mistake. Anyone know what case it was and what Lincoln's claim about that? Well, I mentioned what Lincoln, that it's Lincoln. So it's Dred Scott, but does anybody know what Lincoln said about Dred Scott and how Congress should respond? He said, all right, Dred Scott can't go free, and the Missouri Compromise and the Kansas-Nebraska Act, those laws are now null and void because the court has essentially said they're null and void. All we need to do is just pass a new law banning slavery in the territories and let the courts take up that case. And if they declare that that law is null and void, we'll pass it again and again and again. So this, Hamilton claimed, was another check. Nothing stops the legislature in its capacity of interpreting the Constitution from passing a law again, passing a different law that they think captures the spirit of the first one. So again, let's come back to the question, what does this show about judicial review as we now know it versus judicial review as Hamilton construed it? Well, is this the way we act nowadays? How would people in the United States react, and certainly the punditry, if Congress were to pass a law that the Supreme Court had just declared was unconstitutional? What would be the response? Rabinowitz.
Well, I don't think Congress can pass a law once the Supreme Court has deemed something unconstitutional. I don't think Congress can re-legislate that law. I think it's anything else. Be mistaken that Congress, like, let's say there was a decision in statutory interpretation that they were unhappy with, Congress could then go ahead and reconstitute that law in a different way.
So does what you're saying accord with what Hamilton is saying? What Hamilton is saying. I think that Hamilton is saying the opposite. That Hamilton's saying they could pass any new rule that they want. I'm hearing myself somewhere.
I think we do have something pretty similar to the system today. I mean, Congress does pass laws once the Supreme Court has ruled on something. They're often not like the news-grabbing cases. I think like the constitutional cases, when Congress deems something unconstitutional, I'm pretty sure that you're just not allowed to based off of a 1997 decision. Think of the case in a moment.
You see the problem, though, with saying that Congress can't pass the same law, a new law that says the same thing because of a 1997 Supreme Court decision. In other words, who's telling them that they can't do that? The same Supreme Court, which has just canceled another one of their laws. So it's an endless loop, of course, in this case. But this position that Congress has the power to just simply reenact the law was a long-standing belief in the 19th century. It only fades away slowly in the course of the 19th and 20th century. And it was when Hamilton talked about this as being a real check on the court, as I said, I've come to the position that he wasn't being disingenuous. He really believed that this is something that Congress can do. And eventually it would resolve itself. But Congress certainly had a power to, in effect, attempt to overrule the courts. And there's nothing in the Constitution which forbids that. There's only a Supreme Court interpretation which may say that it's not allowed. So that's his second argument, which I think, again, demonstrates that what we now call judicial review was something which was a much weaker, much more limited idea back in those days, whatever name we give to it. And then another argument Hamilton makes. particular misconstructions and contraventions of the will of the legislature may now and then happen, but they can never be so extensive as to amount to an inconvenience. In other words, if the courts do cancel a congressional enactment, it's going to happen very, very rarely. It's such a majestic thing for them to do that, such an amazing thing to do that. It's awesome for them to actually stand in the way of the legislature, that the courts will rarely do so. So it's only a mere inconvenience. And in fact, the first actual canceling of congressional law was indeed Marbury v. Madison. Anyone know the next time, how many years passed before a congressional enactment was declared to be unconstitutional? You have Marbury v. Madison, first decade of the 19th century, I think 1801, 1802. When was the next one? No one wants to dare hazard a guess or look it up quickly. It's Dred Scott. So we're talking about over 50 years before the next cancellation of a congressional enactment. Judicial review that canceled congressional legislation was a rare, rare thing in the 19th century. And of course, now it's proliferated. So Hamilton, at least for the first 50, 60, 70 years of the Republic, proved to be correct. It's just that developments have taken a different turn in subsequent years. And then finally, Hamilton brought up impeachment. That, of course, the legislature can always impeach and then convict and remove a judge. How many Supreme Court judges have been impeached in American history? I don't mean removed, I mean impeached.
None.
No, one. One has been
I'll take
impeached.
it. I'll take a stab at that. Is that one? Is that Salmon Chase?
Yep, very good. It was Chase. And of course, he wasn't removed. So that means we've removed absolutely no Supreme Court judges. So impeachment has turned out to be an empty threat. The attempt to remove Chase was opposed as such a violation of judicial independence that it should only be done in the most egregious circumstances. What is the actual condition under which a judge may be impeached? What's the thing that a judge has to violate in order to be subject to impeachment? Does anybody know the constitutional language? They serve on good behavior. So
But we've never figured out exactly. We've never actually figured out what that meant.
Right. Samuel Chase was somebody who would lecture party opponents, people who were part of the Republican Party, in violent language from the bench in district cases, circuit cases that he was involved in. And this was regarded as being a breach of his duties as a judge, very much violating good behavior. But even that didn't rise to the definitions that they decided to develop at that time. Apparently, good behavior is something which has to be really, really, really violated in order to be removed, because we've never done it. So Hamilton's argument here proves to be something which didn't actually pan out. All right, I'm going to turn now just to the initial developments in the early republic, the early constitutional republic. I just have to stop the sharing for a moment because it will be impossible to get the proper screen on otherwise, and talk about the actual first cases that arose in the first decades of the Constitution that established judicial review as an actual right. And I think the first important case, not Marbury v. Madison, is actually the Hayburn case. And I want to get it on the language here because I think it's very indicative of the way people thought about judicial review back then. Here we go. Nope, wrong screen. Okay, so here we go. The Hayburn case. So the Hayburn case involved a congressional law which had established pensions, and under the law, Congress had ordered the courts, had given the courts the power to tell government officials, essentially a writ of mandamus, local government officials, to issue pensions. And in this particular case, in Pennsylvania, I believe it was, a local official had not issued a pension. The pensioner, or the one would-be pensioner, had asked the court to issue the writ of mandamus, and the local court in Pennsylvania, National Court, rendered the decision that they were not empowered to, in effect, act as a jury in this case. There's that same idea that, you know, that they don't really have standing to do that type of thing, or the authority to do that type of thing. And so they refused to carry out the law. They didn't actually say that the law was unconstitutional. They just said that the law was something which they did not think was properly written and did not really confer the authority which it wanted to confer on the courts. But here's the language that I think is important. The high respect, now here they are defying the legislature, telling the legislature they're not going to carry out the law. The high respect we intend to entertain for the legislature, our feeling as men for persons whose situation requires the earliest as well as the most effectual relief, and our sincere desire to promote, whether officially or otherwise, the just and benevolent views of Congress, so conspicuous on the present as well as on any other occasions, have induced us to reflect whether we could be justified in acting under this act personally in the character of commissioners during the session of the court, and so on and so forth. What's telling about this language in which they're defying the law or defying Congress's intentions? What seems to be so telling about it? What's the affect, the tone of the way in which they're telling Congress, we're not going to do what you want us to do?
It's deferential.
Yeah, it's respectful, deferential, apologetic, regretful. And what does that suggest then about Hamilton's claim that defiance of Congress would be a rare, exceptional thing? Does it seem to suggest that Hamilton was right about that, if they're being so deferential and apologetic at this moment? Too convoluted a question? Does the apologetic tone, the regretful tone, suggest that this court thought that this was an exceptional thing, something which should be done rarely, or something which was just a matter of course for a court to do? I'm going to be silent until someone answers.
It implies that this is a rare, sort of almost embarrassing thing to come up. It shouldn't come up so often.
Right. And so, once again, in the early days of the Republic, insofar as we had something which approaches what we end up calling judicial review, it was a much more limited, much weaker authority for the courts. It certainly doesn't suggest that the courts were being set up to become a more authoritative and, in my opinion, a more supreme branch that they've become today. And even Marbury v. Madison, which I'm not going to go into in any detail, doesn't suggest that, because as I said, it took another 50 years before the Supreme Court is going to declare another congressional act unconstitutional. And in fact, I think that most of the scholarship on Marbury v. Madison nowadays would say what the court was doing was something not only very limited, but very limited for a particular reason. Does anybody here know what the essential, not the details of the Marbury v. Madison case, but what essential principle or what threat to the court the law that they declared to be unconstitutional might represent? What was it that Marbury v. Madison canceled? What congressional law or attempt? Anybody know?
Wasn't it elements of the 1789 Judiciary Act?
It was exactly. Do you remember which elements it was?
I think it was actually granting the court expanded jurisdiction over certain things. It was actually a very clever way to explain judicial review to a Congress that was Republican controlled and very circumspect of the Federalist judges.
Right. In fact, what it did was it took something, the power to issue a writ of mandamus to a public official, like the Secretary of State in this case. It took that power and it said it's going to be a part of original jurisdiction of the Supreme Court. And the Constitution, when it spelled out what was supposed to be under the original jurisdiction of the court, had not listed that as one of the things that the court should hear originally. So in effect, what this congressional law, which established the federal judiciary, 1789 law did, was it took something which presumably was appellate jurisdiction, because it wasn't in the list of original jurisdiction, and said this will now be in original jurisdiction. So you're right, it expanded the power of the Supreme Court. Why, aside from the political cleverness of it, which is that the court seemingly was being careful and cautious by not expanding its powers, modest one might almost say, why was it so doubly clever, politics aside, for the court to say, Congress can't give us a new power? Why is Marshall very, very determined not to want Congress to have the power to make the court more powerful?
Now the court has the final say on on how to interpret the Constitution.
Well, wouldn't Marshall want that?
I'm saying Marshall wants the court to have the final say on how to interpret the Constitution by saying that Congress doesn't have the right to give expanded original jurisdiction, and the Constitution is a law of the land, and only we, the court, can determine how to interpret it. That gives the court much more power.
Well, but okay, yeah, another comment, yeah.
I mean, I think what you can give, you can take away.
That's, I think, what's going on here. If Congress has the discretion of shifting around what's original, what's appellate, then they could whittle away at what's appellate, take it away entirely. They could whittle away at what's original and make it appellate. They could just simply remove powers. And I think what Marshall was doing in this particular case was he was spelling out, we are not going to allow the court to be constituted or given authority or losing authority by enactments of Congress. That's something which the court is going to defend bitterly. So, you know, it was a very clever decision. And I think those of you in the room who are lawyers and know your Marbury v. Madison and Constitution know that Madison's interpretation of the Constitution that led to this ruling that the law was unconstitutional was so, to me, patently wrong, because the lines of the Constitution that follow the spelling out of the original and appellate jurisdiction literally say that everything else is going to be under appellate jurisdiction. And then insofar as Congress may determine otherwise. In other words, the Constitution actually says that Congress has the power to change that. And Marbury, I think, deliberately misquoted and misinterpreted the decision, the Constitution, in order to defend the authority and the integrity of the court and its makeup and its powers. A very early example of very creative interpretation of the Constitution, which is going to be part of the next part of the series in which we look at some what I regard as being really egregious decisions in which the court made rulings which were thoroughly at odds with the intentions of the law and certainly not required under any reasonable interpretation of the Constitution. So it's 8 o'clock. Anyone have anything they want to say about this? Comments? Questions? I'll stick around for a while.